Basak Chamkamon, says the charged person. What is your father's name? Says the president. The charged person, Mr. Kumriam. My mother's name is Tang Tilai. What is your wife's name? Says the president. How many children have you got? Says the president. May I request that I sit next to my defense counsel and ask them to talk on my behalf because I cannot speak now, says the charged person. Could you state again? I cannot hear you. Says the person. I cannot speak. I find it difficult to speak, so that's why I request that my defense counsel speak for me, says the charged person. The president, pursuant to Rule 21(1)(d) of the internal rules, you are presumed innocent as long as your guilt has not been established, and you have the right to be informed of any charges brought against you, and you have the right to be defended by a lawyer of your choice and the right to remain silent. I now invite Judge Naitol to read out the report of examination. Thank you, the President. Say, Judge Naitol, I would like now read out the report of examination. The extraordinary chambers in the Court of Cambodia, the pretrial chamber, criminal case file number 002-1209, 2007, ECCC OCIJ, in brackets, PTC 17. Report of examination. This report is divided into two main sections. Number 1, proceedings. Number 2, examination of the case by the co-rapporteurs. Number 1, proceeding. I would like to inform the court that this main item number 1, point A, will not be read out. Judge Naitol, I will then skip to the following paragraph so that we can save time. B. The co-investigating judge's order on extension of provisional detention. On the 11th of November 2008, the co-investigating judges of the ECCC issued an order extending the provisional detention of the charged person, who has been detained since the 14th of November 2007 for another term not exceeding 1 year. The co-investigating judges found that the first criterion to order provisional detention mentioned in Rule 63(3)(a) is met, as there are well-founded reasons to believe that the charged person committed the crimes with which he is charged. To reach this conclusion, they rely essentially on the analysis of the case file that was undertaken by the pretrial chamber when seized of the charged person's appeal against the initial order for provisional detention, whose conclusions have not been undermined by exculpatory evidence. The co-investigating judges found that there has been no change in the circumstances since the pretrial chamber decided that provisional detention is a necessary measure to ensure the presence of the charged person during the proceedings, to protect his security, and to preserve public order. They thus considered that these three grounds set out in Internal Rule 63(3)(b) are still met. The co-investigating judges further found that no reasonable conditions of house arrest could be imposed, which would guarantee the objectives of Rule 63(3)(b) 3 to 5 to the same extent as provisional detention. They considered that detention for nearly 12 months is not excessive in view of the scope of the investigations, the complexity and gravity of the crimes of which the co-investigating judges are seized, and added that the exercise of the right to remain silent by the charged person, although recognized and undisputed, is not conducive to speedy proceedings. C. Ieng Sary's appeal brief. On the 10th of December 2008, the co-lawyers for the charged person filed their appeal brief against the order of the co-investigating judges, in which they request the pretrial chamber to vacate the order and order provisional release for the charged person, or subsidiarily order the co-investigating judges to modify the conditions of detention and impose house arrest. They do so on the grounds that the co-investigating judges have not conducted their investigation with due diligence and have not respected the charged person's fundamental rights. D. Civil party co-lawyers joint response. On the 26th of December 2008, the co-lawyers for the civil parties filed a joint response to the appeal in which they request the pretrial chamber to dismiss the appeal as the extension order of the co-investigating judges is reasonable, justifiable, and the discretion is properly exercised. E. On the 9th of January 2009, the co-prosecutors filed their response, requesting the pretrial chamber to dismiss the appeal on the main ground that the charged person has failed to demonstrate any material change in circumstances since he was originally detained by the co-investigating judges on the 14th of November 2007. 2. Examination by the co-rapporteurs. A. Diligence in the conduct of the investigation. The co-lawyers for the charged person submit that the co-investigation has not been conducted with due diligence, as very little evidence has been placed on the case file relating to Mr. Ieng Sary or the other charged persons. This results in a breach of the obligation to hold a trial within a reasonable time, and the charged person cannot be deprived of this right for the more reason that he has chosen to exercise his right to remain silent. The jurors and the civil parties submit that the accumulation of evidence on the case file since the filing of the introductory submission negates a claim of missing due diligence. In any event, the co-prosecutor states that a lack of due diligence on the part of the co-investigating judges is not relevant to the determination of provisional detention under Rule 63(3)(a) and (b) of the internal rules. They further observe that the exercise of the right to remain silent has not been held against the charged person, adding that a charged person can, better than anybody else, assist the co-investigating judges in discovering exculpatory evidence. B. Burden of proof. The lawyers for the charged person contend that the burden of proof is on the co-investigating judges to demonstrate that the conditions of Rule 63(3)(a) and (b) have been fulfilled, and that human rights jurisprudence has consistently found the risks which justify initial detention diminish over time.
កងការពារជូនជនត្រូវចោទទៅបន្ទប់បាទ
The interpreter repeats. The president asked the guards to take the charged person to the room.
Le président a demandé au service de sécurité de raccompagner la personne mis en examen à la cellule de détention. Mais comme je disais, j'ai pas vu ce qui se passait dans la salle. Est-ce qu'il a fait un signe?
Non, non, il y a du bruit là, ça va.
The president May I ask that my client sit next to us, says Mr. Ieng Sary. The President say we agree. The President, now I would like the rapporteur judge to continue reading out the report. Thanks, Your Honor, the President. B. Burden of proof. The co-lawyers for the charged person contend that the burden of proof is on the co-investigating judges to demonstrate that conditions of Rule 63(3)(a) and B have been fulfilled, and that human rights jurisprudence has consistently found the risks which justify initial detention diminish over time. The co-prosecutors, in contrast, state that it is the appellant who has to identify a material change of circumstance to necessitate a reconsideration of his detention or a change in detention conditions, but the charged person failed to do so. C. Well-founded reasons to believe that the charged person may have committed the crime or crimes specified in the introductory submission internal Rule 63(3)(a). The co-lawyers for the charged person submit that a higher level of evidence is required to satisfy Rule 63(3)(a) after Mr. Ieng Sary has spent a year in detention while still under investigation. By failing to identify new evidence relating to whether Mr. Ieng Sary may have committed the crimes with which he is charged, to supplement the evidence already identified by the pretrial chamber, the co-investigating judges have not satisfied its burden of persuasion outlined above in relation to Rule 63(3)(a). The co-prosecutors and civil parties respond that since the first detention order, the co-investigating judge's judicial investigation has progressed. The evidence on the case file incriminating the charged person has increased both in volume and gravity in the recent month. Witnesses have implicated the charged person in crimes committed throughout the period of democratic Cambodia, and no significant exculpatory evidence has been found to undermine the determination of the existence of well-founded reasons. D. Consideration of the grounds making provisional detention a necessary measure, Internal Rule 63(3)(b). The co-lawyers for the charged person submit that house arrest is a form of detention permitted by the internal rules and must be considered. Reasonable conditions could be attached to house arrest in order to protect the objectives of Rule 63(3)(b). The co-lawyers contend that the risk of flight identified by the co-investigating judges is hypothetical, since this is no evidence that he undertook activity to flee or interfere with the administration of justice. Conditions such as 1. Confinement to his residence, 2. Confiscation of his passport, and 3. Placing his residence under armed guard would ensure the charged person's presence at trial. The co-lawyers for the charged person point out that there is no actual risk to Mr. Ieng Sary's personal security. The co-investigating judge's assumption that imprisonment is the necessary form of detention once it becomes public that there is an alleged nexus between Dutch and the charged person is entirely based on a presumption of his guilt, as it takes as certain that such a nexus exists. And B, the alleged guilt of Dutch is borne equally by Mr. Ieng Sary. Concerning the objective to preserve public order, Rule 63(3)(b)(5), the co-lawyers for the charged person refer to reports that, in their view, demonstrate that the situation in Cambodia is actually far more stable and peaceful. The co-investigating judges did not consider what the court as a whole could do to ensure that a risk to public order would not materialize, and the co-lawyer suggests that if the extensive outreach and public relations facilities of the ECCC properly explain that house arrest is a form of detention, no threat to public order would materialize. The co-prosecutors respond that no new evidence was provided since the pre-trial chamber decided on the 17th of October 2008 that provisional detention is necessary. The rules do not provide for alternative forms of detention other than detention at the ECCC detention facility. Only Rule 65(1) provides a release on bail. But a charged person cannot be released on bail if any of the conditions under Rule 63(3)(b) are met. The co-prosecutors submit that even if a charged person were to be put under house arrest or hospital detention, this would not satisfactorily mitigate risk to his personal safety. He would be required to come to the ECCC premises on different occasions, and it would be difficult to ensure his safety during transportation from the hospital or his house to the ECCC to attend publicly scheduled hearings. The ECCC detention facility, on the other hand, is properly equipped to provide medical assistance as required. The co-lawyers for the civil parties respond that the incident that occurred between the civil parties and the co-lawyers for Khieu Samphan during a press conference after the hearing shows the high tension within the Cambodian society and the risk for the charged person's safety if he were to be released. Phnom Penh, 23rd of February 2009, co-rapporteurs, Judge Naitol, Judge Katinka Lahus. The President, the charged person, please come before the court.
he speak, he talk. So he.
But he already said that he was leave the will to the lawyer.
Yeah. Look, Ieng Sary,
The President, Mr. Ieng Sary, would you like to make a statement related to this appeal, or would you like your co-lawyers to speak on your behalf? The charged person, I am very old and I cannot speak much, so I would like my co-lawyers to talk on my, speak on my behalf.
La parole à ma place.
The President, I would like the Defense Counsel to make your oral submission concerning the appeal against the provisional detention. You have 1 hour and a half for this submission. You now take the floor.
The co-defense lawyers. Good morning, Mr. President, Your Honors. Good morning, participants. My name is Ieng Sary, and with me is Mr. Michael Canavas. We are honored and privileged to represent Mr. Ieng Sary. Over the next half an hour and a half, we will be addressing the various issues raised in our appeal against the OCIJ's extension of the provisional detention order of 10 December 2008. Our submissions will be brief on these issues because we have clearly set out our position